Our next part is on a fireside chat involving Scott and Justice Ramesh Khannan. Justice Ramesh Khannan was appointed Judicial Commissioner in May 2015 and Judge of the High Court in April of 2017. He was also appointed as a Judicial Commissioner of the Supreme Court of Brunei Darussalam on a part-time basis on 7th of October 2019, where he hears both commercial and civil cases in that court. He graduated from the National University of Singapore, admitted as advocate and solicitor in 1991, and appointed senior counsel in 2012. Before his appointment as JC, Justice Ramesh was managing partner of TKQP from 2008, where he specialized in dispute resolution, insolvency and restructuring, and international arbitration. He was also appointed a board member of Singapore Aerospace Manufacturing and M1. In the former, he had an added role as executive committee member, while in the latter, he was chairman of M1's risk committee, as well as member of their nominating and audit committee. He's a member of Singapore Academy of Law's Law Reform Committee and vice president of the III Executive Committee and part of III's Arbitration and Conciliation Working Group. He was instrumental in establishing the Judicial Insolvency Network, or JIN for short, which issued in October 2016 guidelines for court-to-court communications and cooperation in cross-border insolvencies. Justice Ramesh has also written Getting the Deal Through Restructuring Insolvency in 51 Jurisdictions Worldwide, all the way back in 2010. As you know, that speaks well of his depth of experience in insolvency and restructuring. He also co-authored the Singapore chapter of the World Bank publication, Doing Business, Closing a Business Survey, that was published in 2009, 2010, and 2011. Can we please welcome Justice Ramesh Khannan onto the stage for the next part on a fireside chat. Thank you, Justice.
Well, it's maybe a great opportunity to turn the table now on the judge, and we haven't rehearsed very much of this, so although it was billed as a fireside chat, I initially expressed my surprise that we'd be sitting anywhere near a fireside in Singapore, so this is a virtual fireside chat. We also haven't really explored whether we'll take questions from the audience, but I think if anybody has a burning question within the audience, I'm sure there'll be enough time to take it. And not at all in insult style, but we're running behind time. So I think we will go as scheduled for about 15 to 20 minutes and try and respect the timetable as much as we can. So welcome, Judge.
Welcome, Scott. Welcome. Hello, everyone. Good afternoon.
I might just begin with a question that really comes out of one of the observations that has been made today, and that's this concept of good forum shopping. And I've always found it interesting that insolvency and restructuring practitioners like to distinguish between good and bad forum shopping, and there have been some very animated panel discussions over the years about this. But would you be able to share with the audience your perspective on this concept of the DNA within the system and how we should be able to create an ecosystem which is optimal for debtors to consider entering?
It's a good question. So I don't like the term forum shopping. I don't like the word shopping. We're not shopping, we're selecting. So it's about forum selection, good forum selection, and it's about finding good restructuring solutions. And it's really in that context that you look at the question of the ecosystem that best offers that the opportunity of achieving those results. So from that point of view, the DNA of the ecosystem has several key attributes, or should have several key attributes. First and foremost, it must be a system with a strong rule of law framework. That's a given, right? And with that comes certain key components: a strong bench, a strong restructuring set of tools, legislative tools, a strong pool of expertise in the market, a strong debt restructuring community in the market, and generally speaking, the capacity to raise capital to basically find solutions for the troubled company. Now, if you look at these factors collectively, you're really looking at major legal and financial hubs. And this is a point which the minister referred to and you had also referred to in your remarks. We are then really talking about what I would describe as nodal jurisdictions. And we can name several off the top of our head, and I think everyone knows, I don't need to list them out here. But really, it's about finding nodal jurisdictions which offer you the best chance of solving your economic problems.
Can I take us back a little bit in time? We've heard a lot about the reform process, and you've been consistently involved in the design of many of the initiatives that have led to the restructuring hub concept and the modernisation of Singapore's system, not Insol's, it's Singapore's. And it would be interesting just to get your perspective on what the drivers were that led to that initiative, but also how did you persuade others and bring along other stakeholders and advocate for this model, which even a few years ago would have sounded bold and ambitious?
Well, I think the journey started in 2013 with the first committee, which was tasked to review Singapore's insolvency laws, and by that I mean corporate and personal insolvency. That committee produced a report in 2013, and that went to public consultation. Feedback was received, and I think the process that kicked off. But I think there was a paradigm shift in 2015 when the Minister for Law, Mr. K. Shanmugam, Senior Counsel, constituted the committee which I was involved in. That committee was co-chaired by Minister Indrani Raja, and the minister who spoke this afternoon was a crucial member of the committee, as well as several members of the bar. I think that the remit that was given to this committee was really the key driver. We were basically asked to reimagine Singapore's insolvency and restructuring landscape, and we were given basically a clean slate to decide how best to do that. We were also given clear targets in terms of deliverables and in terms of timelines, and then we got down to our discharging our obligations. We started work in, I think, May 2015, and the report came out in 2016. Government got to work looking at our recommendations, a whole slew of recommendations across a spectrum of issues. And the first reading of the relevant legislation pursuant, which essentially picked up many of the points that we had recommended, was before Parliament in 2017. Parliament passed it in 2017, and the law came into force. This was really what you would use in basketball terms, a full court press. I mean, the key elements of the state, the Ministry of Law, the executive represented by the Ministry of Law, the judiciary, the Attorney General's chambers, and members of the bar, important members of the bar, as well as academia were on this committee, and everyone was pulling in one direction with a clear focus and with a clear target in mind and with a clear idea of where we're going to go. And we got things done. And in 2017, we got things done in Parliament. The journey didn't stop there. We have continued since, as the Minister's outlined, and we are still looking to improve.
And so, in addition to that, or maybe sitting in parallel, of course, are the Judicial Insolvency Network guidelines, and there's been considerable uptake of the JIN guidelines across the world. Can you tell us a little bit about what role those guidelines play and how they've helped continue cooperation and coordination with other courts?
So, I mean, Justice Swanshi is there, and he was one of the main movers of the JIN and the JIN guidelines, so he will also add to this point when he's on the stage. I think it's important first to remember that the 2013 committee recommended adoption of the model law. And so we were just carrying through that point in the work that we did with the 2015-2016 committee. And the model law, Article 25 requires, or as an obligation to communicate between courts. It makes it as a key component or a key point of importance for the model law. So by the time the JIN met in Singapore in 2016, it was a known fact that we were going to adopt the model law. And as I said, the work had already been started with the legislative process on that score. I mean, it's an interesting snippet as to how the JIN came about. I mean, it was a very informal thing. I mean, I was having lunch. We have a judge's lunch every Wednesday. And just so happened on this particular occasion, I was sitting opposite the Chief Justice, having a conversation with one of my colleagues about, why courts don't talk to each other enough in restructuring. And I thought the Chief Justice was actually having a conversation with another colleague across the table and not listening to what I was saying. And after about 15, 20 minutes of my ranting, he leaned over and said, well, Ramesh, why don't you start a network? And I said, what are you talking about? And he said, why don't you start a network of judges who can, in a sense, flesh out the obligation that you've been talking about, or the idea of courts talking together. And that's when the process started, and the JIN was born, and the JIN guidelines were issued in 2016. I think what's important about the JIN, it's not the guidelines, it's the relationship that we have formed. There are 21 of us in the JIN, and the members come from all the leading commercial and insolvency courts in the world, of the world. And it's the opportunity to sit down, share ideas, become friends, which I think has set the stage for the effectiveness of the work we have done and we are doing. And I think that's the big difference. I mean, you can't communicate and cooperate if you are not familiar with the person you are talking to, and if you don't have a level of deep trust with that individual. And I reckon that the JIN has played a huge part in achieving that level of comfort and trust, and long may that continue.
So I went to my first INSOL conference in 2005, and on the cooperation piece, it's quite interesting because I can remember, maybe not at that conference, maybe subsequently, we all, of course, diligently went along to the judicial panel. That was always the closing panel to make sure people turned up to the end of the conference, as of course people always do. And I can still remember around that time, some judges were very clear that they would not engage in cooperation or communication. It was almost impossible to conceive of that universe, where of course we know in the US, even at that time, there had been already well-noted situations where that had indeed happened, Maxwell Communications being one, and there were others that could be called out, but not that many. So in the period of your judicial career, have you observed a significant shift in terms of the amount of cooperation that is now happening across the restructuring and insolvency judiciary globally? And if so, what do you think has driven that?
Well, I think there's no real issue with common law courts. And I think there was always a willingness to engage in communication and cooperation. And I think it's as a result of the familiarity we have, or the commonality of the system that we share. I do accept that with civil laws, well, not all civil law jurisdictions, certain civil law jurisdictions, there might be, I wouldn't say reluctance, but a little apprehension in engaging in communication. But I should say, we have 3 civil law jurisdictions, and these jurisdictions, the native tongue is not, or the language of the courts is not English, who are observers on the JIN. And I think that speaks to, in a sense, a willingness to embrace this concept, even amongst jurisdictions who would not naturally engage in court-to-court communication. And I think that's a massively positive start. The JIN is very aware of this, the need to widen the scope of engagement beyond common law courts, and in fact, there's a call scheduled very shortly to talk about this amongst the JIN judges, or a certain group of JIN judges. So, I suppose you should wait to see.
So can I traverse the topic of the other model laws that
Yes.
we've discussed? So there is such popular support generally and broad understanding of the impact of the existing model law, the one that's had its 25th celebration. But the two new model laws, for whatever reason, have not been so rapidly embraced, and certainly in relation to recognition of insolvency-related judgments, there are a number of different issues still floating around in the atmosphere in relation to that topic. And then, of course, the Gordian knot, while there is a model law there that seeks to deal with group insolvencies or group enterprise insolvencies, it might be the case that there's still some work to be done in relation to that issue because it's so complex and there's clearly no magic solution. But are there any perspectives that you're able to share in relation to those model laws, or perhaps the issues that sit around just the substantive complexity in those two domains?
Right. I mean, the judgments model law, let's call it that, is really a reaction to Rubin and Eurofinance, and obviously the jurisprudence out of the U.S. Is different from the Rubin position, and so the existing model law, the original model law, from the U.S. point of view, is adequate and sufficient to deal with the recognition and enforcement of insolvency judgments. As the Minister has mentioned, and I think you have as well in your remarks, we have nudged in the same direction as the U.S. There are judgments, and I've also made an order recognizing a U.S. plan. So our position is, at least as the state of the law stands today, is aligned with the position in the U.S. So I guess each jurisdiction has to take a view as to whether they are on the Rubin side of the fence or they are not. And that's really the first question, or that's the answer to your first point on the insolvency judgments or judgments model law. The group enterprise model law is a quite different creature. It serves a quite different purpose. And it's a recognition that companies have evolved since 1997 when the first model law came into force or was adopted by the Commission. Now companies organize themselves, or the economic or the business is organized around a group with multiple entities, and it's also recognition of globalization because companies are now spread across the globe in different parts of the world, and within the continent they're spread in different countries in that continent. But they all serve a common economic purpose, and the model law recognizes that. And that is why the structure of the model law, there are four concepts in the model law which are key: the planning proceedings, the group insolvency solution, the group representative, and I think the fourth factor which sort of flies under the radar is the synthetic secondary proceedings. And these are the four factors which essentially speak to the centralization of the restructuring conversation in one forum. And that's the structure of the model law. And I spoke on this particular model law in a paper I delivered in February 2021 at the University of Texas. And the point I also made was, you don't actually need to adopt the model law to use these concepts in any restructuring. These are readily portable, easily used concepts. And as long as the courts and the practitioners are prepared to be innovative and are prepared to embrace these concepts are there to be used regardless of whether you have these model laws adopted by a parliamentary instrument.
I might just invite if there's any questions, and if you have a question, then after this little topic that we explore, I'm very happy to take the question, and we're probably then getting dangerously close to the coffee break as well, so I'll try and keep us roughly on track. The Singapore Convention, of course, was signed into existence 2 years ago. You don't need the Singapore Convention to have mediation, and many jurisdictions globally are very familiar and use mediation in different ways. But what are your perspectives on, I guess, the full extent of the possibility of mediation in insolvency and restructuring, and where are we at? Are we really just still at the fringes? Have we fully realised the ambitions of mediation and unleashed it in a way that could be far more impactful?
Well, I've spoken to Justice Sonji about this on several occasions, so he knows my thoughts on this. It is something that's embraced very warmly in the US, and it's used in several contexts, both within a domestic setting as well as in a cross-border setting, and in terms of restructuring different types of debt obligations. Unfortunately, it's not something that has caught fire in Asia as it stands. But I'm a big fan of not just mediation, ADR and insolvency. I think it's not something that the Asian insolvency community has really given enough thought to. And examples or the utility of ADR, mediation and arbitration in insolvency is obvious. If you take it in a cross-border setting where you've got, let's take a group insolvency solution between different estates, and the estates are broadly working together to find a common answer, but there will be issues in terms of how you will divide the plan or divide the economic solution between the different estates, because there are different groups of creditors that are involved in relation to the different entities. And how do you resolve those issues without scuttling the restructuring conversation is an important part of the whole process. Now, one has to ask the question, are those issues best resolved in a court, or are they best resolved in a consensual setting, which mediation offers, or even if it's not possible to resolve it in that setting, is it possible to resolve those issues in an arbitration agreement entered into between the representatives of those two estates, or the three estates as the case may be, depending on how many estates are involved in that particular point. So my view is that ADR should be, ADR mediation and arbitration should be something that should be warmly looked at in Asia. And the lessons or the examples are there in the US for us to follow. And certainly the SICC will look at it very, very closely. I think Justice Sonji will look at it, and if I get the opportunity to sit in the SICC on insolvency filings, I will certainly look at it.
INSOL launched its mediation and arbitration, or now ADR colloquium, at London in June, and the uptake was extraordinary, and the amount of interest has been intense. And so I think in no time at all we'll see a broadening of the discussion. Some have already been speaking of the possibility of using skilled mediators alongside financial advisors to help in the facilitation and development of the restructuring plan, which certainly has to be one potential extension of the use of mediation. So this is a great opportunity to ask a question of the judge, for those feeling brave enough to ask a question from the audience. Lawrence, I'm not seeing too many hands go. Oh, there's a question there. So there's a microphone there. Perhaps you're best to come to the microphone and just introduce yourself and please ask your question.
Thank you. Judge, I mean, you have had the experience of practice and being a judge and the like. I've not seen the new rules, but what is it in terms of the procedure of the SICC, bearing in mind whatever the new rule is, which would incentivize or cause parties to actually want to use the SICC from a procedural point of view? Is there any particular benefit in using the SICC for an international restructuring?
Well, I think first and foremost, you must understand what is the jurisdictional touch point for the SICC. So you obviously have to satisfy jurisdiction under the IRDA. And you need to also establish that the dispute is international and commercial, and that's a clear definition given specifically with regard to international, right? And from that point of view, if it's a restructuring which has got a hugely international flavor, right, then the debtor who seeks to file might find the SICC particularly pertinent for all the reasons why the SICC was originally constituted to hear international disputes. You've got an international bench, you've got a set of rules which we will continue to improve, which in a sense allows for a great deal of innovation. If you look at the rules that were introduced in 2021 for bilateral litigation for the SICC, is a completely different set of rules which gives a huge dose of flexibility to the court as opposed to the rules that preceded that. And we will continue to have that same degree of innovation and flexibility in the SICC for insolvency filings, which perhaps we may not have with regard to domestic filings or filings in the general division. And there's obviously now the opportunity of having foreign counsel appear and address the court on issues of foreign law, which under the general division is not available to the parties or to the parties involved in the filing. So from that point of view, I mean, the SICC, in a sense, opens up possibilities for a case that has got a significant dose of international flavor. It also, I would suggest, helps the court to come to a better landing, because if you have foreign counsel appearing and addressing a restructuring which has got a large part of its plan or its insolvency dealing with factors and legal issues which are outside Singapore. And you then have assistance from foreign counsel to guide the court to what should be the right solution or right answer or right conclusion that should be arrived at in that particular case.
So I think we're right on 4 o'clock. We don't have too much more time to go without eroding the afternoon panel. So Lawrence, I might hand back to you to give the guidance for the coffee break. And if you would please join me in thanking Justice Ramesh for the fireside chat today.